Good afternoon. I'd like to call to order this meeting of the Senate Judiciary Subcommittee on Immigration, Citizenship, and Border Safety. I'm Alex Padilla, chair of the committee, joined by ranking member Senator Cornyn from Texas. Good afternoon, everybody, and thank you for joining us for this second hearing of this subcommittee on immigration, citizenship, and border safety. I'm honored to convene this hearing today to examine the impact of immigration policy on our military service members, veterans, and their families. I want to begin by thanking committee members and our witnesses for joining us today. Special thank you to Senator Duckworth for her leadership on this issue and for participating in today's hearing. Also want to particularly thank Mr. Howard Bailey and Lieutenant Colonel Margaret Stock for your service to our country and for participating today as well. We owe you a debt of gratitude. To help set the stage, let me just give some background. Less than 1% of people in the United States choose to serve in the armed forces. Less than 1%. As soldiers, sailors, and National Guard members, these brave individuals risk their lives to keep America safe and to secure our position in the world. The choice to serve in uniform is an act of patriotism. And so it should come as no surprise that military attracts a disproportionate number of immigrants and members of immigrant families. As the proud son of immigrants myself, I know how brightly the American dream shines in our families. I know my parents left everything behind to come to the United States to build a better life. My parents always impressed on my brother, my sister, and I the importance of service to others. And today, indeed, all three of us are public servants in different capacities. So while we didn't serve in the armed forces specifically, certainly do have cousins and now nephews who have and are serving currently. The American dreams of immigrant families are reflected in our military statistics as well. Approximately 5,000 permanent residents enlist in the military each year, bringing us to a total of 45,000 non-citizen members serving in active duty, and more than 700,000 foreign-born veterans. Of those foreign-born veterans, 17% have not been naturalized as of 2018. Non-citizen recruits bring critically needed skills to our armed forces. According to the Department of Defense, on average, non-citizen immigrants enlist with higher education credentials and aptitude scores. Many of these recruits speak strategically necessary languages and have healthcare training critical to supporting military missions. The Center for American Progress finds that non-citizen enlistees are more likely to make it through basic training and more likely to stay in the military beyond 4 years of service. In total, around 13% of veterans are immigrants and children of immigrants. But the critical role of immigrants serving in the military is not reflected in our immigration policy. Changes to the Department of Defense and the Department of Homeland Security policies under the Trump administration has led to a 72% decrease in military naturalizations. And you can see that sharp decline in the chart behind me. These restrictive policies undermine Congress's clear intent to provide an expedited naturalization process for military service members and for veterans. Under the Trump administration, the USCIS terminated its Naturalization at Basic Training initiative, which provided on-site immigration resources so enlistees could begin the naturalization process. That initiative helped to prevent the deportation of veterans by ensuring that non-citizen enlistees would be naturalized before leaving service. Under the Trump administration, the USCIS also shuttered the vast majority of its field offices abroad, cutting the number of naturalization sites from 23 down to 4, which are open for just 1 week each quarter. The Trump administration's cruel cutbacks have made it much harder for honorable service members to become citizens. As a result, active duty military members have instead found themselves in deportation proceedings. Thousands of non-citizen veterans now live at risk of losing their lawful status. We must act to repair the damage caused by these policies. In addition, an estimated 11,800 current service members have a family member facing deportation. It's hard to imagine the stress of serving in uniform while worrying day in and day out that your parents or spouse might be deported. But that's just what happened to Cesar Flores, a senior airman in the Air Force and the son of Juana Marie Flores. Juana supported Cesar's decision to enlist at the age of 19 and cheered him on when he graduated from basic training in September of 2016. But in April 2019, she faced a choice to either get into a van with ICE or to be deported or to leave on her own. The cause was a fateful decision Juana made over 20 years ago to leave California to visit her ailing mother in Mexico. She was arrested when she tried to cross back into the United States without documentation. Juana's undocumented status and then her deportation weighed on Cesar's mind every day as he served our country. Earlier this month, Juana was thankfully granted humanitarian parole for 1 year and was reunited with her 10 children and 18 grandchildren. But this is a temporary victory for Juana and her family. We must do so much more as a country for military family members. We must examine the cases of honorably discharged, deported veterans and their families and allow them to apply to return home. Members of our armed services and their families deserve a pathway to citizenship that accounts for their service. And there's no question that building that path is a matter of military necessity. Our armed forces rely on the bravery, dedication, and skills of immigrant recruits. Finally, I want to express my support for the critical special immigrant visa program for Afghans who supported the United States troops. I'm deeply concerned about the fate of these individuals after the withdrawal of U.S. forces from Afghanistan. Time is not on our side here, and our government must act quickly. Last week, Senator Cornyn and I introduced the Honoring Our Promises Through Expedition for Afghan SIVs Act of 2021, which would help pave a more expeditious path to safety for these Afghans and their families. We must continue to stand with all of those who honorably risk their lives to protect our country. So look forward to hearing from today's witnesses about how we can better serve the immigrants who have courageously stepped up to serve in uniform. With that, I'll now turn to Ranking Member Cornyn for your opening remarks.
Well, thank you, Chairman Padilla, for holding this hearing. It's fitting that in this final week before the Independence Day recess, we take some time to recognize those who've made sacrifices for our country through their service to the United States, through the United States military. I'm proud of our country's long history of including immigrants in our armed forces, which dates back to the Revolutionary War. In 2019, the Migration Policy Institute estimated that veterans who were born outside the United States represented about 3% of our 18.6 million veterans. Our immigration laws provide an expedited path to lawful permanent resident, for those, let me read that again. Our immigration laws provide an expedited path to citizenship for lawful permanent residents who serve in our military. This is the right thing to do. Someone who's followed our immigration laws and is willing to make the ultimate sacrifice for our country and our American values is an excellent candidate for citizenship. In general, a lawful permanent resident must reside continuously in the United States for 5 years before applying for citizenship. I'm proud to have played a small part in making it easier for those enlisted in the United States Armed Forces to apply for naturalization. When I first got to the Senate, lawful permanent residents had to serve a total of 3 years in the armed forces before they became eligible for a waiver of the 5-year continuous presence requirement. I introduced the Military Citizenship Act of 2003 to eliminate naturalization application fees for service members and to reduce the 3-year service requirement to 2 years. I later successfully joined forces with Senator Ted Kennedy in getting this language included in the fiscal year 2004 Defense Authorization Act. And we ultimately agreed through a conference committee, which I was a part of, to lower the 3-year service requirement further to just 1 year. I'm proud of the work we've done to lower barriers for naturalization for our brave immigrant servicemen and women. Chairman Padilla, you and I can agree that we should make it easier for lawful permanent residents who are serving in the armed forces to receive the naturalization benefits that they've earned. And I hope we can, through this hearing, we can identify some of the other things we might do together on a bipartisan basis to further streamline the naturalization process for our service members. I'm not comfortable, however, with some of the proposals that have been introduced in Congress regarding veterans who've been removed from the United States as a result of committing a serious crime. The Veterans Visa and Protection Act of 2019, for example, would have terminated removal proceedings and rescinded removal orders for veterans who were imprisoned for less than 5 years on account of their crimes. It would also have given the Secretary of Homeland Security broad authority to waive the bar on veterans who are imprisoned for 5 years or more for a crime of violence. There are very serious crimes that are punished with sentences of under 5 years. For example, under the California Penal Code, sexual abuse of a minor can be punished with as little as 3 years in state prison. Also, in California, second-degree robbery is punished by imprisonment for 2, 3, or 5 years, and some first-degree robberies are punishable by only 3 years. These are, I hope we would agree, very serious offenses, including drug trafficking offenses that are not necessarily crimes of violence and would not bar rescission of a removal order under this proposed legislation. I see no reason to impose a blanket bar on removing non-citizens who commit very serious offenses like this. DHS and our immigration court system are much better equipped to make decisions about whether to remove such offenders. That said, I'd like to also turn to a more urgent issue that falls squarely within the subcommittee's jurisdiction and within the topic of this hearing, our obligation to the translators and interpreters who assisted our troops in Afghanistan. The U.S. has fought for 20 years to beat back the Taliban's violent and oppressive hold on that country. The United States and its allies opened the way for democracy, rule of law, civil society, and equal rights for men and women and girls in Afghanistan. Much of what we accomplished during our time in Afghanistan would not be possible without the help of brave Afghans who answered our call for help. These men and women were with our troops every step of the way, helping us speak with their communities and building the foundation for a democratic society. Now, in their most desperate hour of need, President Biden has chosen to abandon our allies and leave them to the wolves. With the U.S. military withdrawal, the Taliban is already taking control of Afghanistan, imposing its oppressive military regime and dismantling civil society and the democratic processes. In the 6 weeks since the Biden administration announced the withdrawal from Afghanistan, the Taliban has taken control of 32 districts, now controlling a total of 106 of Afghanistan's 387 districts. According to an article in the Wall Street Journal yesterday, thousands of Afghans who supported our troops are at risk of retaliation by the Taliban as we pull out of the country. In 2006, we established the Special Immigrant Visa Program for Afghan and Iraqi translators, creating a pathway for them to become lawful permanent residents and eventually citizens. Then in 2009, we passed the Afghan Allies Protection Act, which set aside an initial block of 1,500 special immigrant visas for Afghan nationals who were employed by the U.S. government in Afghanistan for at least 1 year and experienced an ongoing serious threat on account of their service. Unfortunately, according to the Wall Street Journal article, Congress's efforts to help these men and women have become mired in bureaucracy. The State Department has a backlog of about 18,000 pending applications, and the U.S. Embassy in Kabul recently stated that it would pause interviews for visa applicants due to concerns surrounding COVID-19. Mr. Chairman, I'd like to ask unanimous consent to enter this article into the record.
Without objection.
Thank you. A recent report by the State Department Office of Inspector General found numerous problems with the Afghan Special Immigrant Visa Program, including inadequate staffing and a lack of centralized databases to track the cases. Unfortunately, it's going to be difficult at best to correct these programmatic deficiencies in the little time they have remaining. We need to attack this problem on all fronts through legislation and better congressional oversight. Fortunately, a few proposals have been introduced in Congress to aid our allies. As you said, Mr. Chairman, we worked together to introduce the Honoring Our Promises Through Expedition or HOPE for Afghan Special Immigrant Visas Act of 2021. This bill is a companion to legislation introduced by Representatives Jim Crow and Brad Weinstrup in the House. It would temporarily waive the medical exam requirement for applicants to this program, removing one hurdle for their admission to the United States. I want to recognize Chairman Padilla's willingness to work together with me on this issue on a bipartisan basis, and I'm hopeful we can act quickly and provide some relief to our Afghan allies. We need to get this legislation passed as soon as possible. I understand our colleague, Senator Kennedy from Louisiana, also has a bill, the Save Our Afghan Allies Act, which would require the Defense Department to coordinate with the State Department to develop a plan to relocate and admit the Afghan nationals who supported our troops in the United States. With your permission, Mr. Chairman, I would ask that we grant Senator Kennedy 5 minutes at some point during this hearing to give him an opportunity to speak about his important work, and I appreciate that. And of course, Senator Shaheen and Senator Ernst and Senator Wicker have long worked on this same issue, having introduced a package of reforms that would increase the number of visas and lower certain requirements in order to facilitate our allies' swift departure from danger. We need to do more to engage with the administration to make improvements within its existing authorities, and this hearing provides us an opportunity to identify and discuss those issues. I think one of our witnesses, Ambassador Ryan Crocker, who's had a lot of experience in this region, can be very helpful to us, and I look forward particularly to his testimony on that in that regard. So, Mr. Chairman, I look forward to learning more about the situation our Afghan allies face as a result of the decision to pull out of Afghanistan and how we can use our immigration laws to protect these brave men and women. Thank you.
Thank you, Senator Cornyn. Today, we do have two panels scheduled, two panels of witnesses that we'll hear from before questions from the committee. First, we will welcome members of Congress to testify on the topic of immigration and citizenship policies for U.S. military service members, veterans, and their families. We will first hear from Senator Tammy Duckworth, who I believe is joining us virtually. And after Senator Duckworth, we'll hear from Senator Kennedy. I understand he is on approach. Senator Duckworth is participating virtually, so as we prep the tech, let me briefly introduce Senator Duckworth from Illinois. She is an Iraq War veteran, Purple Heart recipient, and former Assistant Secretary of the U.S. Department of Veterans Affairs, who was among the first handful of Army women to fly combat missions during Operation Iraqi Freedom. Senator Duckworth also served in the reserve forces for 23 years before retiring at the rank of Lieutenant Colonel in 2014. Senator Duckworth, the floor is yours.
Thank you, Mr. Chairman. I would like to thank the Chairman and Ranking Member Cornyn for the opportunity to speak on this very important issue. The time has come for Congress to demonstrate our loyalty and service to the immigrant service members and veterans who have demonstrated their loyalty to the Constitution in serving our nation. These are proud Americans who simply wish to become citizens of the nation whose uniform they've proudly worn in service. There's no doubt that immigrant service members are a critical part of our military. Since the Revolutionary War, immigrants have enlisted in the United States Armed Forces and fought to defend our nation and its ideals. Now, the United States rely on immigrant service members in all sectors of the armed forces, and they are powerful assets in strengthening our national security and protecting our homeland. Making sure that immigrant service members, veterans, and their families can access naturalization services is not just the right thing to do, it's a wise strategic policy decision that empowers our military to selectively recruit from broad and diverse talent pools, which ultimately enhances our military readiness. That is why for over 200 years, Congress has provided service members an expedited path to citizenship, and both Democratic and Republican administrations have worked to streamline the naturalization process for service members. Especially in times of conflict, Congress specifically intended for service members to naturalize as soon as they entered service and prior to their deployment. Theoretically, naturalization through military service should be a seamless process, especially as it serves our national security interests. In reality, far too many service members never gain the citizenship they've earned through their service. Some of our service members are fighting overseas only to fear that they or a loved one could be detained and deported by the same country that they are defending. Or worse, some don't even realize that they're not yet citizens, and like many Americans, mistakenly believe that citizenship automatically accompanies honorably serving in uniform. And coming home presents a new set of challenges, with many veterans turning to self-medication rather than seeking proper treatment or care, leaving them vulnerable to the unforgiving nature of our criminal justice system and immigration laws when we fail to properly diagnose them with post-traumatic stress. Take, for example, one case of combat veteran Miguel Perez. After serving 2 tours of duty in Afghanistan as part of Operation Enduring Freedom, Miguel returned to the United States suffering from undiagnosed post-traumatic stress disorder and without legal status. The United States Army failed to help Miguel naturalize on 2 separate occasions prior to his deployment and upon his return to the United States. He, in fact, had started to fill out paperwork and thought that everything was proceeding smoothly. The system also failed to make sure Miguel was provided proper support and care after suffering a traumatic brain injury from a blast in Afghanistan, and he fell into a spiral of self-medicating with just his full VA healthcare benefits that he had earned and was entitled to, and faced even greater challenges seeking the naturalization he should have earned during his time in service and his sacrifice. I wish that I could say Miguel's case was an anomaly, but the truth is we don't even know how many veterans have been deported because the United States government fails to even maintain a detailed record of the veterans and military family members it callously removes from our country. Just a few years ago, I spent Veterans Day in Tijuana, Mexico, meeting and talking to some of these veterans in a community created and run by this incredible organization, the Deported Veterans Support House. These veterans are asking for our help, asking us to live up to our obligation to support and protect our nation's veterans, regardless of their immigration status. We in Congress have the ability to take substantive, concrete action that could bring these veterans home and make sure that no other individual who served our country honorably is deported again. That is why I've introduced several bills to protect and support immigrant service members, veterans and their families, like the Veterans Visa and Protection Act, the HOPE Act, and the IVETS Act. My legislation would prohibit the deportation of veterans who are non-violent offenders, give legal permanent residents a path to citizenship through military service, and strengthen VA healthcare services for veterans. Our country has a duty to support our military members, veterans and their families, and I look forward to working with you all to make sure that we fulfill that duty. Again, thank you for inviting me to speak today on this critical issue, and I hope that today's conversation inspires more solutions in this area. Thank you, Mr. Chairman.
Thank you, Senator Duckworth. I don't believe Senator Kennedy has arrived. If it's okay, we'll proceed to the second panel of witnesses and afford Senator Kennedy an opportunity when he does arrive in committee. Thank you again, Senator Duckworth. Now let me lay out the mechanics for the rest of today's hearing. After I introduce and swear in the witnesses, they will each have 5 minutes to make their opening remarks. We will then begin our round of questions by committee members. Each senator will have 5 minutes. And I ask that we all please try to remain within our allotted time since we do have other Senate activities later in the afternoon. So I'm going to begin by introducing Colonel Margaret Stock. She's a retired lieutenant colonel and an attorney with the Anchorage office of Cascadia Cross Border Law Group, LLC, where she devotes her practice to immigration and citizenship matters. She transferred to the Retired Reserve of the U.S. Army in June of 2010 after serving 28 years as a military police officer in the Army Reserve. While a professor and reservist assigned to the U.S. Military Academy, West Point, New York, Colonel Stock was temporarily asked to work for the U.S. Army Accessions Command, where she developed and implemented the Department of Defense's recruiting program, Military Accession Vital to the National Interest program. She also worked on many other issues related to immigration, citizenship, and military service, including the Naturalization at Basic Training Initiative. In 2008, she earned the American Immigration Lawyers Association Pro Bono Award for founding the AILA Military Assistance Program. Finally, she was named a MacArthur Foundation Fellow in 2013 for her work related to immigration and national security issues. We will also hear from Howard Bailey, a deported U.S. veteran who lives in exile in Jamaica due to his deportation nearly a decade ago. Mr. Bailey was born in 1971 in St. Anne, Jamaica. He moved to the United States when he was around 17 years old after obtaining lawful permanent resident status through his U.S. citizen mother. He joined the U.S. Navy after high school and served for nearly 4 years, including 2 tours in Operation Desert Storm. He was awarded the National Defense Service Medal and honorably discharged. After Mr. Bailey's service to the U.S. Navy, he devoted himself to his wife and his 2 U.S. citizen children, purchased a home, and started not 1 but 2 small businesses, including a thriving trucking company employing 7 people. Mr. Bailey was deported in 2012 after a conviction that has since been pardoned. We will also hear from Ambassador Crocker, a non-resident senior fellow at the Carnegie Endowment for International Peace. Other academic appointments have included diplomat in residence at Princeton University, inaugural Kissinger Fellow at Yale University, and the James Schlesinger Distinguished Visiting Professor at the University of Virginia and Texas A&M, where he was Dean of the Bush School of Government. He was a career Foreign Service officer who served 6 times as an American ambassador in Afghanistan, Iraq, Pakistan, Syria, Kuwait, and Lebanon. He serves on the board of advisors of No One Left Behind and received the Presidential Medal of Freedom, the nation's highest civilian honor, in 2009. Other recent awards include the West Point Association of Graduates Thayer Award in 2020 and the inaugural Bancroft Award presented by the Naval Academy in 2016. Also in 2016, he was named an honorary fellow of Literary and Historical Society at University College. I would ask that each of the witnesses please stand and receive the oath. Please raise your right hand. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Thank you to witnesses participating both in person and virtually. Colonel Stock, you may proceed with your opening statement. Sorry to interrupt. Make sure your mic is on. It's a faint light when it's on, but
I think it's on now.
there you go.
Should I
Thank
start
you very
over?
much. Please start over.
Chairman Padilla, Ranking Member Cornyn, and distinguished members of the subcommittee, I'm honored to be here to discuss the impact on military members, veterans, and their families of recent changes, policy changes at the Department of Defense and the Department of Homeland Security. My theme here today is that we best honor military service by keeping the promises that we have made to service members and by following the law. In the last 5 years, DoD and DHS have not been following the laws. Instead, together they have created new policies that undermine the laws. Our broken legal immigration system has made it harder for immigrants to obtain the lawful permanent resident status that they must have in order to serve our country. When immigrants do volunteer to serve, DoD and DHS prevent them from joining the military and stall their naturalization as United States citizens. Family members have not been able to access benefits to which they're entitled, and the immigration agencies continue to try to deport military members, family members, and veterans. The current policies do not make our country safer. In fact, they harm military recruiting, hurt readiness, and prevent the United States Armed Forces from using the talents of immigrants. The new policies hide behind false national security rationales to conceal anti-immigrant motives. In 2006, when I previously testified before a Senate committee chaired by Senator John Warner on issues pertaining to the military, another witness at the hearing, General Peter Pace, the chairman of the Joint Chiefs of Staff, broke down in tears when discussing his immigrant mother. He, like many in the military, had immigrant parents. Before 2016, having immigrant parents wasn't a barrier to service. But today, persons with immigrant parents who seek to serve in our military are viewed with great suspicion and can be discharged from service for having foreign ties. One bright spot recently is that DHS has issued a memorandum reversing several years of policies whereby DHS attorneys were regularly refusing immigration benefits to military family members. This change has been long overdue, and I applaud DHS for announcing this new guidance. To reverse policies that harm our military and get DoD and DHS back on track to keep the promises that we've made, I recommend that Congress do the following. Direct USCIS to restore the Naturalization at Basic Training Initiative. Repeal the sunset clause on the Military Personnel Citizenship Processing Act. Reintroduce and enact the Military Enlistment Opportunity Act, which allows recipients of deferred action for childhood arrivals and other legal immigrants to enlist. Codify the military parole in place and deferred action programs. And finally, enact legislation to prevent the deportation of honorably discharged military veterans. Until recently, a significant advantage of military service has been that non-citizens serving in the military have been permitted to obtain expedited U.S. citizenship. Expedited citizenship benefits not only the non-citizens, but it also benefits the military. In return for expedited citizenship, military members can lose their citizenship if they subsequently fail to serve honorably for 5 years. In 2017, DoD made 2 key policy changes to the naturalization process that undermine the law. Because of these changes, and contrary to the purposes of the military naturalization statutes, it's often now faster for green card holders seeking citizenship to remain civilians. Further, there are few reliable resources readily available to assist military members and veterans. The military provides wrong information to enlistees. Just today, while I was preparing for the hearing, I got a message that Fort Jackson had told a soldier newly arrived there that she could not apply for citizenship. The military has no established system for tracking cases, and the responsibility is left largely up to the military members themselves. The VA does not assist them. Many who want to apply for citizenship are slipping through the cracks. DoD has also made it much more difficult for non-citizens to join the military in the first place. While the Bush administration has previously authorized lawful immigrants through the Military Accessions Vital to the National Interest Program, the previous administration ended the MAVNI program. This change has hurt the military's ability to attract talented immigrants and reduce the percentage of immigrants serving. Facebook and Google can recruit talented immigrants on our college campuses, but military recruiters are no longer permitted to do so. Military recruiters report to me that they're meeting recruiting quotas by lowering their standards. The previous administration internally floated proposals to end the popular military parole in place and deferred action programs that began under the Bush administration. Congress has indicated its support for these programs, but codification of these programs would ensure that a future executive branch cannot dismantle them. Our founders knew that immigrants were a powerful asset to the United States, and particularly to the United States military. Today, it's no different. America can't fight effectively without immigrants. The recent policies harm our national security. Congress must act through legislation and oversight if we truly want to honor the service of the non-citizens who have sworn the oath of enlistment and put their lives on the line for our nation. We must keep the promises that we've made to them. Immigrants are an asset to the United States Armed Forces, but only if we let them live up to their potential as Americans by choice, unfettered by the chains of the broken immigration system. Thank you, and I look forward to your questions.
Thank you, Colonel Stock. We'll now turn to Mr. Bailey, who's participating virtually. Mr. Bailey, please proceed with your testimony.
Good afternoon, everyone. My name is Howard Bailey. I am an honorable discharge veteran of the United States Navy. I served in both Operation Desert Storm and Providing Comfort. I joined the military to serve my country and make my family proud. Navy recruiters came to my high school and I quickly enlisted. I signed up for the pre-entry program while I was still in high school, and I worked on an aircraft carrier during the weekends. I graduated in May, and by August, I was at boot camp. It was hard. Some guys washed out, but I stuck with it. When I finished, I was proud to show off the uniform I had worked hard to earn. I have now been living in exile for 8 years. 10 years if I include the 2 I spent in immigration jail fighting my case. Before I was deported to Jamaica, a country I had not seen in nearly 25 years, I was a happily married man with 2 American kids, a home I purchased with my VA loan. I owned my own trucking business, had 4 employees, paid my taxes. I was a lawful permanent resident, and in my mind, I was living the American dream. The last time I saw my home was 10 years ago. And since then, life feels like a total nightmare. Every day I hope that I would wake up and just be back home in Virginia again. You see, in 1995, about 6 months after I got out of the military, I was arrested because a package of marijuana was mailed to my home from a friend I recently met. I didn't know there was marijuana in the package. The cops told me not to worry. I was about 22 years old. It was my first time I remember ever being arrested. But I still had to go to court. My lawyer told me to plead guilty rather than take my chances with a trial. He told me this was just going to be a slap on the wrist and everything's going to be all right. He did not say anything about immigration. 25 years later, I'm still paying. In 2010, 15 years after I received the marijuana conviction, I showed up at my front door to take me away. See, I had recently applied for citizenship. And when the application asked if I had ever been convicted of a crime, I said yes. I even went to the courthouse to get the paperwork to show that the case happened since I did not have any record of it. Then one day, I heard a knock on my door. It was about 5:30 in the morning. When I answered, I saw all these guys in khaki suits and a state trooper. I got scared. I had no idea what was happening. It was ICE, and they told me they were taking me away because of the conviction and my prior visit to INS. Even though it was so many years ago, ICE grabbed me, and they didn't care that my 11-year-old daughter came out screaming and crying. My wife had to beg them to allow her to give me a pants to wear since I was only just in my pajama shorts. I haven't seen my daughter in 10 years. My deportation traumatized her. Her mental health suffered all through her teenage years and into today. She didn't make it to college. Her dreams and mine too. It ripped my heart out that my daughter was hungry at times and I couldn't do nothing at all. My son has had troubles with the criminal legal system, and I blame myself. I wasn't there when he needed me the most. Young men in America need their fathers. He had just turned 14 when ICE dragged me away. Before my deportation, I fought my case for 2 years from an immigration detention center. I was moved around from one detention center to another. New Mexico, Louisiana, Pennsylvania, just to name a few. After I was deported, I got a pardon from the governor from my marijuana conviction, but I still couldn't come home. The governor told me his hands are tied and that he can't make ICE do nothing. Many people have tried to help me, even Senator Manchin, but I still won't budge. I thank you all for listening to me today. My name is Howard Bailey, and I do love my country, and I only wish to come home to the United States. Navy forever, man. Thank you, guys.
Thank you, Mr. Bailey. Now our final witness, Ambassador Crocker, also participating virtually. Ambassador Crocker, the floor is yours.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member Cornyn, it's an honor to be with you today to discuss another aspect of the critical issues involving non-U.S. citizens serving with or for our military forces. That's the Special Immigrant Visa Program, and in particular, the program as it is being applied in Afghanistan. President Biden has made it clear that he is withdrawing all U.S. forces by 9/11, the 20th anniversary of the attacks on the American homeland. It is likely to be completed even before that. Over 50% of our forces have already been withdrawn. The embassy has stopped processing special immigrant visas for Afghan interpreters because of a COVID outbreak. The Taliban, meanwhile, continue to advance, occupying district after district. I'm here today, Mr. Chairman, to try to be a voice for Afghan interpreters. These are people we have a moral obligation to that is extensive. We could not have engaged in Afghanistan with any success at all, or in Iraq, without them. As has already been noted by Senator Cornyn, there are roughly 18,000 potentially eligible individuals waiting for visas. We need to get these people to safety, in my view, before we complete our military withdrawal. That, sadly, is not likely to happen. I became involved in the SIV issue during my time as ambassador to Iraq in early 2007. Two members of our Iraqi national staff at the embassy were killed. I mention this because these are real issues. These are not pawns in partisan politics. These are human beings who have served us and have risked and given their lives in some cases to do so. The Afghan Special Immigrant Visa Program, it's good news and bad news. The good news is that it's now in its 12th year. It has had bipartisan support over 3 administrations, 7 Congresses, 5 Secretaries of State, and 7 Secretaries of Defense. The bad news, it still does not function quickly or predictably. And now we are at a crunch point. It's not that nothing has been done. I would join in thanking Senator Shaheen for her major effort to expedite the process. Mr. Chairman, you and Minority Leader Ranking Member Cornyn have also taken important steps. Senator Kennedy, Senator Duckworth, Senator Ernst. These are all important, and as an advisory board member of No One Left Behind, I would like to thank you most personally and sincerely. The process is, if not broken, it's certainly inadequate to the challenge we now have. There are 14 steps that an applicant must go through to get a visa, and it takes years. You'd actually have a better chance, I think, of bringing world peace on the basis of Woodrow Wilson's 14 points than getting an SIV with the 14 hurdles that applicants have to jump. Just this weekend, a veteran contacted me pleading for some action to bring his interpreter to safety. Defense contractors, in this case, have failed to give the applicant a letter, and there's no means to compel that letter to be issued. And again, the clock is running. The individual emailed the vet to say, quote, "If the Taliban get me, you know they have no mercy." I leave it to your imagination to imagine the impact this has had on the veteran I'm talking about. I can provide further details if anyone on this committee is interested in helping. I do not see any way in which the current SIV system is going to function magically, swiftly, comprehensively to take these interpreters out of mortal danger. There has been talk of an evacuation, and we now may come to that. It would have significant hurdles to cross to make a difference. If the backlog is 18,000 and we are prepared to evacuate them without completing the SIV processing, well, if you figure 4 family members for each visa, you're talking over 17,000 people. How do you get them securely to an airfield that we control? I mean, how do you even get there? When you have a mass movement like that, how do you get them there safely? How do you process them? Where do they go? What happens at the other end? I don't have the answers to these questions, but I think it is beyond important that we ask them and that we find a way forward. There are other issues too. If we do a mass evacuation for SIV eligible, potentially eligible individuals, that will instill a panic, I think, in the population of Afghanistan and its security forces and its government. We will have to weigh that as well. So I have, of course, submitted a statement for the record. I would just conclude by saying that without White House engagement, NSC engagement, to take control of a faltering process, make the decisions, make this a top priority, getting these people to safety, it's just not going to happen. It takes a toll on our veterans, as I just mentioned. Those that protected them, they are now unable to protect in turn. CBS has a new,
Ambassador,
very compelling series.
if I can ask you to wrap up, we want to proceed to questions.
Yes, sir. CBS has a series, The United States of Al, which features a Marine resettling his Afghan interpreter. Here's a quote from one of the episodes. "When we decided to join the U.S. forces, we were not only risking our own lives, we were putting the lives of our family in danger. We were the eyes and the ears of American troops. And that's what the Taliban called us, the eyes. Shoot the eyes first." I can't say it any better than that. Viewers thought so too, writing in to offer shelter and support for these interpreters. I would hope, even at this very late date, the Biden administration will step forward, follow the lead of the American people, and ensure our national honor is not left behind with those who risk their lives for us. Thank you, Mr. Chairman.
Thank you, Ambassador. Thank you to all of our witnesses. We'll now turn to questions from members of the committee, and I'll begin. My first question is for Colonel Stock. For hundreds of years, the United States has recognized the importance and the need for immigrants to be part of our military. In 1952, this concept was codified in the Immigration and Nationality Act, the INA. The INA has specific provisions dedicated to military naturalizations that waive certain requirements such as residency and physical presence, as well as naturalization and biometric fees that civilians generally have to pay. In addition to military recruiters use naturalization as a way to attract legal permanent residents to join the military. My question, Colonel Stock, is this. Given the history of immigrants serving in the U.S. military and specific provisions in the INA detailing who is eligible for military naturalizations, can you tell us what supports and resources are currently provided by the U.S. Citizenship and Immigration Services and the Department of Defense to help military service members complete the necessary paperwork for naturalization and process their applications?
Unfortunately, Mr. Chairman, right now it's pretty much a mixed bag. USCIS does a very good job with its website, posting information about the process, and it does allow military members to file applications electronically. Unfortunately, the services do very little at the moment to help out. And most military members, for example, during basic training, have no access to the internet, to a printer, to a computer, so it's impossible for them to file an application electronically while they're in training, and they can't access the resources.
That's a great example. Just a quick follow-up. Sorry to interrupt, but was there a time when there were more supports in place to help with military naturalizations? And obviously the question for today would be, what can Congress do to ensure that USCIS and DOD are providing the necessary supports and resources?
There was a time, Mr. Chairman, this was between 2009 and 2018 when the Basic Training Naturalization Initiative was in place. We had a meeting, I was working with the Department of Defense at the time, and we met with DHS, and we decided that it would save the government millions of dollars, promote military readiness, allow service members to be utilized to their best capacity if we naturalize them as quickly in their service as it was possible to do. And so USCIS dedicated teams at the small number of military basic training sites found inside the United States. And these were expert teams that could process applications, do all the background checking and the vetting, test people and so forth. And they were extremely efficient and really good at what they did. And then the system was broken in 2018. Applications are now filed all over the place, interviews all over the world. Often we have adjudicators who don't know anything about military naturalization making decisions in the cases, and it's complete chaos, to put it bluntly.
So if I connect some dots in your response there, reinstating these programs would be a big help.
Reinstating these programs is easy, and it would go far to solving all the problems. And it would also save the government millions of dollars.
Okay, there may be some more follow-up there, but I want to make sure I ask a question of Mr. Bailey. Mr. Bailey, you're still with us. Veterans that are deported from the United States are often removed, as in Mr. Bailey's case, years, in some cases even decades after a criminal conviction. Many of them have been rehabilitated after they've paid their debt to society and are productive members of their communities. Pulling them out of their homes for previous infractions seems cruel and unnecessary. According to the report by the ACLU, nearly all deported veterans have left behind families who have struggled in their absence. In addition, veterans are often forced to return to a country they do not know and have few ties to. Mr. Bailey, I want to thank you for your testimony. It's clearly difficult for you to talk about your deportation and separation from your family. Can you just spend another minute on what your life has been like since returning to Jamaica and how your family was affected back in the United States when you were forced to leave them? And if you can just spend a brief amount of time telling us what it would mean for you to have your case reopened and reconsidered.
Yes, sir. Well, I left Jamaica when I was pretty young, 16. So I really didn't have a life in Jamaica. Being deported here, life have been really, I mean, it's hard to imagine. I came here with nothing except a pair of jeans, that one that I put on when ICE took me. I had to sleep on the floor. I had nowhere to live. I was just dropped off in a country. But as time goes by, Jamaica is a hard place to survive. The crime rate is high here. Poverty is high. Deportees are stigmatized. So I live my life in fear because we are often the target of some vicious attacks because I don't know what it is. They stigmatize people who are being deported from the United States. It's not just me, hard on me, it's on my family. My mother, who is in the United States, who her health has declined from all the grief and the sorrow and all the emotion stress she's going through, to know that her son's life is in danger and I'm not home. My daughter has suffered tremendous mental health. When I left, she tried to commit suicide twice. She had to get a lot of counseling. She didn't make it to college, you know. Me and my kids was really close. My son, as we speak here today, is in the penal system. I just can't forget the 4 words he always tell me when we used to talk until I can't hear from him again, and I'm scared to wonder if something happened. He always used to say, "Dad, you're not here, Dad. You're not here, Dad." My smaller brother, he served in the military because he had followed my footsteps. They said big men don't cry, or men are not supposed to cry, but I cry with my brothers, man. It's hard. You know, my sister, everyone is in the United States except me. If I should get a chance, just a chance, this is something that me and my family hoped and prayed for, just a chance, so I could come back and be in my kids' life and bridge that gap and be a father figure. No, I can't do nothing about the past, but I can steer the future. I'm just asking for a chance to come home to the country I love, the country I serve, the States of America.
Thank you. Thank you, Mr. Bailey. Thank you. At this time, I'm going to turn the hearing over to Ranking Member Cornyn so I can go vote on the Senate and return quickly. Thank you.
Well, thank you, Mr. Chairman. Let me start maybe with a couple of quick questions for you, Colonel Stock. I admire your work in helping to create the Military Accessions Vital to National Security, or MAVNI program. I agree that the TPS holders and legal permanent residents and others who are not yet citizens can make valuable contributions to our country. But I wonder, is there any crime that could be committed by a legal permanent resident like Mr. Bailey that would justify deportation?
Absolutely, Senator. But as you said earlier, and I agree with you when you made this comment, the immigration judges and the folks who are experts at the Department of Homeland Security are best positioned to make the call about whether somebody should be deported. Unfortunately, in 1996, Congress eliminated their ability to do that and took away all their discretion to make a judgment call about whether a crime was serious enough to deserve deportation or not. In 1996, Congress basically eliminated all the discretion that the judges would have in ordering a deportation and completely tied their hands. So today, if somebody's in front of an immigration judge, the judge looks at the statute and the laundry list of crimes that Congress stuck in the statute and says, you did that, you're gone. You did that, you're not. And it's literally a laundry list. It includes some misdemeanors as well as some serious crimes. I'm for restoring the discretion that immigration judges need because they're the ones best positioned, as you said earlier, to make the decision on whether somebody should be deported or not.
Do you think Congress should set some parameters for the judge's discretion?
Absolutely. A good example is the definition of aggravated felony in the Immigration Code. That definition doesn't include things that are aggravated and doesn't include things that are felonies. And if it were up to me, I would repeal the current definition, which is just a laundry list, and I'd replace it with a very simple one that says the crime has to be a felony and you had to serve a significant criminal sentence for it, and it has to be aggravated as well. And then we'd be honest about who we're actually deporting. Right now, there are people who are tagged with the aggravated felony definition who served no jail time and committed a misdemeanor. And that's just wrong, and it's not just.
Mr. Bailey, you're still with us, I trust. As I understand it, you were deported in 2012 during the Obama administration. Is that correct?
Yes, sir.
Is that correct, sir?
Yes, sir. Can you hear me?
Okay. And at the time, National Public Radio described you as, quote, exactly the type of people that the Obama administration said they're focusing on deporting. Why do you think they would say that?
I don't know, sir. I've never heard that report.
You told us that you have been pardoned. Is that correct? And if so, when did that happen?
It's happened in 2017. I was pardoned by the governor of my state, Virginia.
I'm sorry, you were pardoned by the governor of your...
Virginia.
Okay. So you weren't pardoned by President Trump?
No, sir.
Okay. I was just trying to understand how that would work. So you were not pardoned by an official of the United States government?
I was pardoned by the governor of my state from which the crime occurred.
Okay. Let me turn to Ambassador Crocker. Ambassador, thank you for being with us. I can't think of anybody who we could have before the committee that would be a better witness for both the service that these interpreters, these Iraqis, provided to the United States during our time in Afghanistan. As you know, there are a number of different legislative proposals, but as I look at what's happening on the ground and the aggressive moves that the Taliban has made, is there what you would call your preferred solution to this problem? Can you tell us what the terms of that would be if in fact we could wave a magic wand or pass a bill by unanimous vote of the Congress?
It's an excellent question, sir. It's in my written testimony. The steps, some of which you've been involved in, I think are important ones to bring more high-level focus on this, in particular to ensure that the interagency process functions as it should, and that will require White House leadership through the NSC. DOD has the greatest number of people in this program, but they have neither authority or responsibility for managing it. That is done by state. State does not have the people or the resources. It simply needs to be a top-tier priority, and unfortunately, in the 12 years of this program, it has not been that, not under Republicans and not under Democrats. But we are now faced with a much more immediate and grave situation. The steps that are being taken, including those you have initiated, are important. They will take time. And time is something we do not have. It may be that things won't be all that bad. Who knows? We don't know because it's the Taliban who has agency here, not us. Based on what they have done in the past and the advances they are making now, I would be more than concerned that if we don't find a way to move a lot of people in a short amount of time, that we are going to have a lot of blood on our hands from our Afghan interpreters. And again, this is not restricted to Afghanistan. Memories are short. The internet doesn't forget. So the next time we need support somewhere, and we will, people are going to look at how we handled this situation, and it is not going to be good. So I think there needs to be a conversation, like right now, about the issues surrounding an evacuation of thousands of individuals. As I noted earlier, that will not be easy, to say the very least. But to at least have the discussion right now, I think is something that we owe the people involved, and we owe to ourselves and our sense of who we are as Americans. Our commitments are very honor. So it is not an option that anyone would favor, a last minute evacuation. But the procedural changes that would invigorate the visa processing situation, those will not come in time. I mean, right now, we are not issuing any visas at all because of the COVID epidemic. And that would be another factor in an evacuation, incidentally. But it's the President Biden owns this policy. It's his. I think at a minimum, the White House is going to have to take action to say, this is now a top tier issue. What can we do for these people?
Ambassador Crocker, I just have one more question, and then I'll recognize Senator Klobuchar and ask Senator Blackburn if she wouldn't mind to take the gavel while I go vote, and I'll come back, of course. And that is based on President Biden's decision to withdraw all U.S. military forces from Afghanistan by September the 1st. My understanding is that they're already about 50% of the way through that drawdown. What do you think the status of the Afghan government will be relative to the Taliban at the end of this calendar year?
Well, I can tell you right now that it has been severely undercut. In fairness, this did not start with President Biden. I believe, and I have said from the very beginning, that the decision under President Trump to sit down to pursue a negotiation with the Taliban and without the Afghan government was tantamount to a surrender. That was a Taliban demand from the beginning. We eventually caved to it. And I think what we are now seeing is the unspooling of our support for the government of Afghanistan at an increasingly rapid rate. So President Biden, in my view, inherited a bad hand, but also has played it very badly without, I think, considering the consequences of this withdrawal, this total withdrawal, at every level, what it does to the Afghan government, what it does to the Afghan national security forces, what it does to the interpreters who served us.
Thank you very much. I'll recognize Senator Klobuchar, who's joining us virtually.
Thank you very much, Senator Cornyn, and thank you as well, Chair Padilla, for holding this hearing on this important topic. And I'd also like to thank Senator Duckworth, who I know was there, who testified earlier for her testimony and most importantly, service to our country. So in recognition of the honorable service of our immigrant soldiers, we promised to provide expedited pathways to citizenship. But in recent years, as you all know, the U.S. has imposed barriers to naturalization that leave non-citizen veterans and service members vulnerable to deportation. In fact, from 2016 to 2019, there was a 72% increase in military naturalizations. And of course, we've seen this somewhat across the board. Colonel Stock, you worked on the Naturalization at Basic Training Initiative through cost, though it was cost effective, it was efficient, but it was terminated in 2018, making it difficult for new recruits to complete the naturalization process. Can you speak about the impact of the program's termination and how it has exacerbated service members' susceptibility to deportation?
Yes, Senator, it has had an extraordinarily negative effect on the service members, their military readiness. Just to give one example, I got a call from an officer in Hawaii a couple days ago who said that they have 60 soldiers in the Pacific Rim area who are not deployable. In other words, they can't send them to do their military duty because they're not citizens of the United States, and they can't figure out how to get their naturalizations processed. It's taking an extraordinary length of time right now to naturalize people. I recently handled a case for an active duty soldier in South Korea where she filed the application in 2016, and it wasn't approved until about 5 years later. She had to fly back to the United States twice, COVID quarantine for 14 days each time in order to complete the process. This is not expedited. The agency tells me that they are no longer required to expedite because the Military Citizenship Processing Act had a sunset clause in it. And so since Congress no longer mandates a 6-month processing time, they don't believe they have any deadline for processing military cases.
Yep. A very good example of, by the way, what's going on here. Ambassador Crocker, you previously served, of course, and I thank you for that service as the U.S. Ambassador to Iraq and Afghanistan. Work closely with Congress to establish Iraqi and Afghan special immigrant visas, which grant lawful permanent resident status to Iraqi and Afghan interpreters, contractors, security personnel. These nationals risk and are continuing to risk their lives, and I want to thank Senators Cornyn and Padilla for their work on this issue. I personally had a former commander of our National Guard who has since retired break down in my office one day talking about an interpreter that he wasn't able to get status for and how scared he was for him. What impact would a broken promise have on our credibility in foreign policy, or does it have? On average, sort of similar to my last question, applications take 996 days to process. With U.S. troops withdrawing from Afghanistan by this September, what are some of the measures we can take now?
Well, it's the critical question, Senator. As I noted, the procedural shifts that you and your colleagues have been involved in are very important, but that is not going to work for the short term. I increasingly see no alternative than some effort at an evacuation. But as I've noted, there are incredible problems associated with that. I mean, effectively, I would think it would pretty much halt the withdrawal of the forces we have left. That we would need all of them and probably more, again, to deal with route security, with marshaling, perimeter control. And we would also be in a situation where we're really not able to check on the credentials of the people that might show up at an airhead. So the time for this conversation, sadly, was before the decision was made to withdraw all of our forces. And I simply do not think, I have not talked to anyone in the administration, but I do not think this was even a consideration at the time that decision was made.
Well, we are where we are now, and we need to do something about it. And I appreciate your work on this. And just more broadly, the broader issues of our immigrants who've served in the military. One of my most fond memories in life is meeting a World War II vet who had been brought over. He was a dreamer. They didn't call him that back then. Brought over through no fault of his own, didn't know it. He actually served, signed up to serve in World War II, and that's when he found out that he was not born in America. And as he told the story, he's since died. He was almost 100 when I brought him to Washington. But he said back then they brought him to Canada for one day, and he stayed in a really nice hotel. Back then he thought it was. And then he came back and he was a citizen because they needed him to serve in the military. And he went on to serve under General MacArthur, came back, had a family, and his son served in Vietnam. And it just made me think about the fact that back then it was easier than it is now. And given that we're more and more global, in a more and more global economy and world, it makes little sense that we are not recruiting and keeping our immigrant service members as well as in general, our immigrant population. So thank you very much for your work, Ambassador, and thank you to all the witnesses. Thanks.
Thank you. Senator Blackburn.
Thank you, Mr. Chairman. Ambassador Crocker, it is so good to see you, even if it is just on the screen. And I thank you so much for the great work you have done on behalf of our country. These SIVs are of tremendous concern. I have a family that we're working with there in Tennessee. The interpreter is out. Parents are ready to come out. The frustration with a younger sibling not being out or able to get out, knowing that the Taliban is going to kill every single one of these individuals if the administration and the State Department cannot get their act together on this, knowing that these people are in danger, knowing that they are depending on us. Very frustrated with the embassy in Afghanistan. It is closed because of COVID. They should be working remotely. And Mr. Ambassador, I will tell you, I completely agree with you that we are going to have to get these individuals, send them to a safe third country to get them out of harm's way, and then go ahead and complete this processing. But we cannot leave these individuals to die. And we know that they will, every single one, be slaughtered. So your insights into this region are so vitally important. I just wondered, as you were answering Senator Cornyn's question, how many Afghani nationals are potentially in this program? How many F2As are children? And are there any statutory limits that you feel like would hamper or hinder us moving forward and getting these individuals out of the country?
Thank you, Senator. In terms of numbers, we have about 18,000 individuals in the backlog, and if you conservatively estimate that each individual would have 3 others, say a spouse and 2 kids, and that is a conservative estimate, you're talking about over 70,000 people. So we've got a huge number, and that presents an enormous security and logistical challenge if we have to turn to evacuation. And frankly, I don't see any other alternative right now to evacuation.
So let me just come back to you on that. So actually, to fulfill our promise and our obligation to these individuals that have risked their life to help us and to keep our men and women in uniform safe, we have about 70,000 that need to be moved out before the Taliban, and we hear the Taliban is right now very aggressive in how they're moving into these areas in Afghanistan. So it is 70,000 people that you feel like we need to move to that safe third country so that they can go through the processing, and that you are recommending that we do this by evacuation.
I don't see any other alternative to an evacuation. I'm not even sure, though, that an evacuation is an alternative for the reasons I've just tried to state. I do think there is a necessity that is beyond urgent to have that assessment, that conversation starting right now. And it will, the State Department doesn't have the resources for this. It would have to be effectively a military operation. The military is in no way ready to execute that operation. The White House has got to, in my view, take charge of this contingency. It's their policy. We're all leaving. Got that. So what do we do about, in this case, our interpreters?
Well, I will yield my time back to the chairman, but Mr. Ambassador, as I said, your insights are so important. When I was in the House, I really appreciated on my trips over the time that you would spend with us and having your insights into the application of U.S. policy in this region. So I thank you very much for this. Thank you, Mr. Chairman.
Thank you. We will now begin our second round of questions for senators who wish to ask additional questions. I would like to begin with a follow-up question to Colonel Stock on this topic of the withdrawal from Afghanistan and SIVs. As someone who has represented clients in these special immigration visa cases, what are your views on what should or can be done before the troops in Afghanistan are withdrawn?
Thank you for the question, Mr. Chairman. As I've said on the record in other contexts, the only solution at this point is to invoke the section of the Immigration and Nationality Act that allows for evacuations that have been discussed. It's the parole authority in Section 212, and we have done this before. The Pentagon has taken charge of similar operations in the past. The most memorable one I think that comes to mind is in 1996, Operation Pacific Haven, where we evacuated thousands of Kurds to the island of Guam. And there they were able to do the orderly immigration process in a safe place. That's doable here, but of course it will take leadership at the White House. They'll have to tell the Pentagon to dust off the plans, change the names, and get the resources flowing. But it's perfectly doable with leadership at the top. And again, you wouldn't be processing visas in Kabul. You'd be paroling people into the United States to a safe location. I'm not saying it has to be Guam. It could be Alaska, but someplace where you can keep people safe and you can send the resources in to vet them and process them properly for asylum status or special immigrant visas or other benefits to which they might be entitled.
Okay, thank you very much. Important part of today's record. Next question. It's estimated that there's currently about 11,800 service members who are serving actively who have a family member who is facing deportation. This seems dangerous from a military readiness point of view. If service members are distracted or worried that about the possible deportation of a family member, it could negatively impact their focus on their mission. Furthermore, veterans who have served honorably should not be put through the additional stress and burden of having a family member deported. I recently heard of Alejandra Juarez, a case where the mother of 2 children was forced to self-deport to Mexico. Her husband had served honorably in the United States Marine Corps and was put in a financial and emotional straits when his wife became a priority for deportation after living in the United States for 20 years, more than 20 years. He was forced to support 2 households, one in Florida and one in Mexico, and did his best to care for their daughters. Almost 3 years later, Alejandra was finally allowed to come back home, but her future remains uncertain. Colonel Stock, what remedy is currently available to deported family members of military service members and veterans? And of course, what can Congress do to make sure family members of military service members and veterans are protected from deportation?
This is a very complex problem, and the only remedy in most cases is for the family member to somehow get a hold of some expert immigration lawyer to help them. The American Civil Liberties Union and the American Immigration Lawyers Military Assistance Program have been trying to provide help to these family members. Of course, it takes a lot of work and many hours and lots of experts. Recently, DHS has announced a new policy where they will allow prosecutorial discretion in cases involving military family members. I mentioned this in my written testimony as well. I applaud the Department of Homeland Security for coming forward with this new guidance. I think it'll go far, but people need an attorney to help them request the prosecutorial discretion. And so it's going to be difficult for many people to realize that there's a memo out there and to request this relief.
Thank you. And one additional question for you. According to the INA, military service members are entitled to, quote, expedited naturalization if they serve during a period of active hostility or wartime. The United States has been in a period of active hostility since the war on terrorism began in September 11 on September 11, 2001. Colonel Stock, in your experience, have military naturalizations been expedited or fast-tracked since 2001? How long does the process take on average?
Senator, they were being fast-tracked from about 2002 through about 2016, when the administration decided, at the behest of civilians employed at the Department of Defense, to stop expediting naturalizations for military personnel. And we found this out through various lawsuits that got filed. So right now, they're not expedited. And as I said earlier, I think it would go far for Congress to lift the sunset date on the Military Citizenship Processing Act and restore the mandate that the agency must process these cases within 6 months.
Thank you very much. Recognize Senator Blumenthal for your questions.
Thank you. Thank you, Mr. Chairman, and thank you for having this hearing and your leadership on the subcommittee. And thank you for your testimony today, Colonel Stock. I was disheartened but not tremendously surprised to learn of recent GAO findings concerning ICE's mishandling of veterans' cases, but I was really staggered by the scope of the failings by ICE with regard to our nation's veterans. ICE is required to provide special consideration for veterans' health and military service, as you know, when making a determination to remove a veteran from this country, and must obtain higher approval from a field office, as I understand it, before initiating a removal proceeding. But in 2019, GAO found that in the preceding 4 years, ICE failed to obtain that approval in 70% of the veterans' cases that it reviewed. That means that those veterans did not receive full due process. Veterans of our military did not receive due process. And consideration should have been required under ICE's policies. As startling as the GAO also found that for nearly 15 years, certain groups of ICE agents failed to seek that approval because they were entirely unaware that they were required to do so. This report is troubling, and my question is twofold. First of all, what can be done to assist those veterans? Second, what can be done going forward to improve ICE's performance and restore veterans' trust and our trust in the system?
Thank you, Senator, for that question. I think at the outset I should point out that there are 3 immigration agencies, and to ICE's credit, at least they have guidance. The other 2 immigration agencies, Customs and Border Protection and U.S. Citizenship and Immigration Services, also put military members and veterans into deportation, as well as their family members, and they don't have guidance, and GAO did not look at them. So, for example, in the record today, a sergeant major in the Army, Jeremiah Wagner, put a letter in explaining how Customs and Border Protection summarily kicked his wife out of the country on Memorial Day weekend this year, when they did not have to do that, and they didn't have to check with a supervisor before doing it either, unlike the ICE folks. Going forward, though, as far as what can be done, I think it's important for the Secretary of the Department of Homeland Security to put out guidance to all 3 of the immigration agencies, not just to ICE. ICE does have guidance that was released on May 21st that now mandates that they're supposed to take into account military service as well as the military service of family members when making a decision whether to put somebody into removal proceedings. So I actually have positive things to report about ICE. Unfortunately, I have no positive news to report about Customs and Border Protection and U.S. Citizenship and Immigration Services, which continue to blindly put military personnel, veterans, and their family members in a removal proceeding without any consideration of any equities.
So these are ongoing failures.
These are ongoing
violations of
failures.
due process.
I can give you an example. If you're a military member and you're afraid to be sent back to your country of origin because it's hostile to the United States, let's say you're from Afghanistan and you don't want to go back to Afghanistan and you file for asylum, you're going to file with U.S. Citizenship and Immigration Services Asylum Office. If you don't file your application within 1 year after you get to the United States, they automatically try to deport you. And that's happened. We have a whole bunch of current members of the U.S. military who are facing deportation because they filed for asylum, and USCIS says they missed the deadline for filing.
So we in Congress who are concerned, maybe even justifiably outraged by this
Yes.
issue, should be hammering the Department of Justice and the Department of Defense and the Department of Homeland Security, correct?
That's correct.
I didn't mean hammering in a physical sense.
Well, they need to realize what's happening. It's beyond belief that a current member of the military should be in removal proceedings. That makes absolutely no sense. They're a U.S. government employee in removal proceedings, forced to hire an attorney to defend themselves against the U.S. government trying to deport them.
When they are serving and sacrificing.
They're serving our country right now. They have a military ID card.
Thank you. Thanks, Mr. Chairman.
Thank you, Senator Blumenthal. Seeing no other senators wishing to ask further questions, we'll begin to wind down this hearing. But before we conclude, I want to move to enter a number of documents into the record, including a joint statement from the chairman of the House Veterans Affairs Committee, Mark Takano, Congressman Juan Vargas, representing the 51st District of California, and Congressman Raul Grijalva, representing the 3rd District of Arizona, as well as statements from the American Legion, the Center for Law and Military Policy, retired Judge Frank Ochoa and immigration attorney Craig Rice, and Sergeant Major Jeremiah Wagner. I'd like to also enter into the record a letter that I am sending to Secretary Mayorkas on behalf of Mr. Bailey, requesting that his immigration case be reopened and that he be granted humanitarian parole. He should be reunited with his family in the United States while he awaits a formal decision on his case. Mr. Bailey fought for our country, and I'm happy to fight for him. So without objection, these statements will be included, and want to announce that the record will close 1 week from today. Now, as this hearing concludes, I'd like to thank again my fellow subcommittee members for their participation, and especially to our witnesses for joining us both in person and virtually. The stories of service that we've heard today are just a small fraction of the long history of immigrants serving bravely in our nation's armed forces. Immigrants have played a critical role in every major U.S. conflict, from the first battles of the Revolutionary War to the last troops stationed in Afghanistan today. It's our job to ensure that our immigration laws reflect this outstanding history of service, to recruit individuals with the skills our nation needs, to support justice for people like Mr. Bailey, and to keep soldiers' families safe so service members can stay focused on their missions. We should be making it easier, not harder, for service members to naturalize while in uniform. As the American Legion put it in their statement for the record for this hearing, and I'll quote, "It is a failure of all those involved that service members do not receive citizenship unless they specifically do not desire citizenship or had done something during their service which resulted in a dishonorable discharge." Close quote. Our military needs diverse recruits to stay prepared for the challenges of the 21st century. And immigrant veterans and their families deserve the permanency of citizenship in the country they have given so much for. The Trump administration weakened our national security by blocking paths to citizenship for service members. In some cases, active duty soldiers have faced immigration enforcement proceedings and even been deported from the home they served in uniform. We need a clearer picture for the number of deported veterans and their families. As a recent GAO report discovered, ICE is required to take additional steps prior to removal actions for veterans, like considering their service record. But as of 2019, ICE was not doing that, and therefore we have no real idea of how many members of our armed services and their families were unjustly deported. Veterans, citizen and non-citizen alike, often struggle with the return to civilian life. A number of non-citizen veterans have been removed from the United States as a result of simple transgressions or criminal convictions tied to post-traumatic stress disorder or another physical trauma they suffered while on active duty. It's an outrage that our laws force the deportation of people like Mr. Bailey, who served our country honorably and lost his green card over a simple mistake. We need to bring back transparency and accountability, and ICE needs to follow its own policies to prevent these deportations. Overall, it's clear that we need to act immediately to restore and strengthen the immigration services available in the armed forces. We need to reunite military families separated by deportation. Thousands of non-citizen immigrants, including DACA and TPS recipients, are eager to bring their talents to our military. Restoring programs like MAVNI and naturalization at basic training will increase our military preparedness for any challenge that lies ahead. I again want to thank Senator Duckworth for her leadership in addressing the immigration needs of military families and veterans. Look forward to working with her and all of our colleagues to solve the problems we've heard about today with the urgency that they deserve. Our service members, veterans, and military families deserve a solution, and our national security depends on it. And with that, today's hearing is adjourned.